The 2019 amendments to the 1997 Rules of Civil Procedure were crafted to address the twin problems of docket congestion and delays by institutionalizing procedures that will ensure speedier proceedings, the management of heavy dockets, and the elimination of frivolous or baseless actions. Further, the said rules are meant to be responsive to the needs of court users and are meant to be the judiciary's way of adapting to various technological advancements. Overall, the said amendments are a manifestation of the Supreme Court's commitment to serve the public and the ends of justice through a more efficient and responsive judiciary.
Good morning, attorney.
Good morning. How can I help you?
I'm thinking of filing a case against my business partner because she violated the terms of our contract. I've tried to ask her several times to deliver what we agreed on. She just keeps saying yes, but never delivers. Now she does not respond to my calls anymore. What should I do?
I see. You can file an action for breach of contract against her. You are lucky because the rules of civil procedure have recently been amended and it is now possible to have a speedier resolution to your case. We just need to prepare all the evidence necessary for the case because the new rules now require the complaint to include evidentiary matters, meaning judicial affidavits and copies of your contract, demand letters, and other correspondences.
I have all of those in my file, so I don't think that would be a problem. Attorney, I'm worried that my business partner would try to delay the proceeding to avoid her liability.
Your partner would find it difficult to delay the proceedings under the new rules. Motions that are susceptible to abuse are now prohibited or considered non-litigious, while litigious motions may be heard at the judge's discretion. The provision on the hearing of motions was deleted. The entire Rule 16 on motion to dismiss was also deleted, as most of its provisions are incorporated in other rules.
My business partner has stopped answering all my calls and emails. What if she also refuses to receive the summons?
She would find it more difficult to do that under new rules. The new rules now seek to facilitate the service of summons, expands how substituted service can be done. The provision on extraterritorial service has been amended to include modes of service as provided for in international conventions to which the Philippines is a party, that is, Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, commonly known as the Hague Service Convention.
My partner is very sneaky. I tried to send a demand letter to her, but the receptionist in her condo refused to receive my letter. What if my business partner makes ways to evade receiving papers from the court?
Oh, your business partner can't. There are new provisions on the presumptive service of pleadings and other papers. Now, service and filing through accredited courier, email, and other electronic means can be done to prevent delay in court proceedings. The amendments also require judges to be more engaged as they take on a more proactive role in assessing the merits of the case and the progress of proceedings in general.
I remember from movies that parties can meet for possible settlement before the trial proper. Are these also applicable and were these amended too?
You are talking about the preliminary conference or what we call the pre-trial. The practice of having a preliminary conference before the branch clerk of court was done away with and the judge shall immediately conduct pre-trial. Pre-trial now needs to be concluded before the case is referred to court annex mediation, but only if there is a genuine issue involved. The answer tenders an issue or the answer does not admit the material allegations in the adverse party's pleadings.
My apologies, attorney, for all these questions. But what if the court annexed mediation fails?
If the court annex mediation fails, judicial dispute resolution by the same pre-trial judge may be availed of if settlement is still possible.
Thank you, attorney. I believe that with these amendments, baseless actions will be lessened if not eliminated. How long do you think will the trial take?
The initial presentation of evidence shall take place no later than 30 calendar days after termination of the pre-trial. The continuous trial of civil cases is adopted, whereby the plaintiff and the defendant are given 90 calendar days each to present evidence, which 180 calendar day period may be extended to 10 months or 300 calendar days if there is a third or fourth party claim, counterclaim, or cross-claim.
Wow, at least I know when my case can be completed. With regard to the judge's decision, how long will I wait?
Judgment shall be rendered within 90 calendar days from the submission of the case for resolution, with or without memoranda.
Is there a possibility that my case does not go to trial?
If there is no genuine issue, or if the answer fails to tender an issue, or if the answer admits of the said material allegations, the court may motu proprio submit the case for judgment on the pleadings or summary judgment without prejudice to the party moving for such relief. Such judgment also must be rendered within 90 calendar days from termination of the pre-trial, with or without the submission of memoranda.
If my motion for judgment on the pleadings or motion for summary judgment is granted or denied by the court, can the court's action be questioned before an appellate court?
No. Under the 2019 amendments to the Rules of Civil Procedure, any action of the court on the motion for summary judgment or motion for judgment on the pleadings shall not be subject of an appeal, certiorari, prohibition, or mandamus.
If the case was decided in my favor through judgment on the pleadings, can my business partner make an appeal?
Yes, because the remedy of appeal from a judgment is a right provided by law and the rules of procedure. Under the 2019 amendments to the Rules of Civil Procedure, what shall not be subject of an appeal, certiorari, prohibition, or mandamus is the action of the court on the motion for summary or motion for judgment on the pleadings. If the court grants or denies the motion for summary judgment or motion for judgment on the pleadings, such action on the motion cannot be questioned before an appellate court.
It seems that these new rules will expedite my case if I do decide to file. Attorney, let me try to talk to my partner one last time, and if she really does not respond, I will file the case.
Okay, let me know what you decide.
Thank you so much for your help, attorney.
You're welcome.